Good morning, everybody. My name is Francesco Pesce, and I am a lawyer in Italy and assistant professor in international law at the University of Genoa in Italy. My task here today is to examine the influence of European Union law from one side and the influence of the international law from the other side in the regulation of mediation in Europe. So in all the member states, 28 member states today of the European Union. European Union, we have to remember that the European Union is today a very different international organization than the economic community that was created in the 1950s by 6 member states in the Western Europe. In the first time, the European economic community was aimed at granting the free movement of the so-called factors of production. So we had the free movement of goods, free movement of workers, of capitals and services in the first moment. But then, after the years, so during the second part of the 20th century, the European community has changed, and has changed a lot. And during the 90s, the European community became capable to rule the civil judicial procedure. So the member states asked to the European community to adopt some rule directly binding in the field of civil judicial procedure. This fact is strongly linked to the current regulation of the mediation procedure by the European Union law. We have to remember that in 2007 the Lisbon Treaty was approved, and the Lisbon Treaty entered into force in 2009. And the new competence of the European Union in ruling the civil judicial procedure joined the provision of some human rights contained in the Lisbon Treaty through the European Charter of Fundamental Rights. I make reference to the right to access to justice. So today the European Union says that all member states have to grant to European citizens and to all the individuals that are resident in the within the European Union the right to access to justice. This is very important when we speak about mediation, because the European Union asked to member states to introduce within their national legal system some possibilities to obtain the justice without passing through the judicial proceedings. And one of these possibilities is the possibility represented by the mediation. So today we have, it's sure, we have always the possibility to ask to a judge to grant some rights that we have that are proceeding from the national legal system or from the European Union legal system. But we can also address our request to a mediator through the mediation system. We have to say that the fundamental right to access to justice is not the fundamental right to access to a court. It's a very different concept. We can have the justice, so we can have the enforcement of our rights even without obtaining a judicial pronunciation, thanks to mediation and thanks to, generally speaking, other way of alternative dispute resolution, or ADR. So after obtaining this new competence on civil judicial procedure in 1990s, and after the conclusion of the Lisbon Treaty, the European Union recently has approved a directive in the field of mediation. We have the directive 2008 number 52 that asks to the member states to approve some national rules introducing the mediation inside the national legal systems. The directive asks to the member states to introduce a mediation methods for the settlement of the disputes that is a mediation of a high quality. So the European legislation provides some requirements for the procedure of the mediation. Mediators have to be appointed, approved by national governments to be considered as official mediation in order to settle a dispute. And then the directive requires that the member state, of course, consent to the individual to use the mediation. So today, the introduction of the mediation is an obligation for the European Union member states. But we also have to consider that the European Union law has a very, very well-defined scope of application. So the European community, and today the European Union, can ask and can oblige the member states to introduce the mediation just with reference to the cross-border disputes. So the member states are not obliged by the European Union to introduce the mediation proceedings within their national legal system with reference to totally domestic litigation. But it's sure that such an obligation coming and proceeding from the European Union law, it's a strong incentive for the member states to introduce the mediation as alternative dispute resolution methods, even with reference to the domestic disputes. So, if we have a dispute arising between two individuals that are habitually resident in two different states, so in this case we have a cross-border litigation. But if we have a totally domestic dispute between two people that are habitually resident in the same member state, in this case the member state has the possibility to not to introduce the mediation, but a strong influence is exercised by the European Union law. The European Union law also requires to member states that the mediation agreement is enforceable. So the mediation agreement is useful only if it's possible to enforce it, and not only in one member state, but all over the Europe. The European Directive 2008 number 52 also requires that the mediation proceeding maintains a character of confidentiality. That is typical and characteristic for the mediation. And last but not least, the directive requires that the possibility to use the mediation system does not prevent the individuals going to the court. So we are speaking about an alternative dispute resolution method, but not about a substitution of the normal and the traditional jurisdictional proceedings. So the individuals can use the mediation, but they keep and they maintain the possibility to go to the court after an attempt of mediation. At the beginning of this introduction, I also spoke about international law, because not only the European Union asks to introduce the mediation, but also some international conventions. And I make reference in particular to the European Convention on the Human Rights, the European Convention of 1950. The European Convention contains two articles in particular, Article 6 and Article 13, devoted to the right to a fair trial and the right to an effective remedy. Both these articles, in the modern conception, require that member states introduce the possibility to have another way to enforce the right of the people. Another way, alternative, not in substitution to the jurisdictional way. So if a member state doesn't respect this right to a fair trial and an effective remedy without introducing the possibility of using an alternative dispute resolution method, this state can be condemned by the International Court for European International Court for Human Rights of Strasbourg. This is the point where the European Union law and international law are strictly linked in the requirements that all the member states introduce a mediation system within their legal system. Thank you.